Okay, I guess just obviously by what I'm looking at, that seems, am I looking at the right thing? Dakota Chapman, the first violation is that he committed the offense of murder?
That has been abandoned.
That was
Yeah,
no. Okay,
I'm sorry.
thank you.
We should have started with that.
We're just gonna go to safety and, okay. So,
That was the here's
let's do this. I'd like to go ahead and go through the motions, get pleas of true or not true to the remaining counts, and then obviously if you guys have an agreement, we'll look at that. But I think I want to go through and have those pleas on here.
and that came at the recommendation of the supervisor.
Okay.
I'm sure has much more information for the court as well.
That's good. Thank you. If you want to print this section, I'll just do the first one on here. All right. Will he waive the formal reading of the motion in each case? Mr. Chapman, in clause number 23, DCCR 1077, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation May 6th of 2024 for the offense of evading arrest or detention with the use of a vehicle, third-degree felony, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
And then in clause number 23, DCCR 1078, I also have a motion to revoke your unadjudicated probation. This shows that you were placed on probation May 6th of 2024 for the offense of accident involving injury, a state jail felony, and that was a 5-year deferred probation. Is that also correct? And so the state is going to abandon in each case count 1, correct?
Correct, Judge, based on the comments of the grand jury.
So, Mr. Chapman, in each case, the motions allege you violated your probation. Count 2 in each case alleges that you failed to work faithfully at suitable employment and provide verification of that.
This hearing takes a dramatic turn almost immediately. Notice what's happening here. The most serious allegation, the homicide-related accusation, has already been removed from consideration. That means today's hearing isn't about proving a new crime. It's about whether Dakota violated the conditions of probation. And as you'll soon hear, the list of violations is long. Here's the question for you. If someone repeatedly breaks probation rules but avoids a new conviction, how many chances should the system give them?
And is that true or not true? Count 3 in each case alleges that you provided a urine sample March 12th of 2025 that tested positive for cocaine. Is that true or not true? Count 4 alleges that you provided a sample September 3rd of 2025 that tested positive for methamphetamines and amphetamines. Is that true?
True.
Count 5 in each case alleges that you admitted to your probation officer to using the illegal drug ecstasy December 3rd of 2025. Is that true or not true? Sorry. Count 6 alleges in each case that you were at a location other than your residence at approximately 1:53 a.m. December 21st of 2025. And is that true or not true?
True.
Count 7 in each case alleges that you failed to successfully complete the defensive driving course as ordered. Is that true or not true?
At this point, Dakota has essentially handed the court everything it needs to revoke his probation. Positive drug tests, admitted drug use, curfew violations, failure to complete required programs, unpaid fees. These aren't accusations anymore. They're admissions. Legally speaking, a plea of true can be one of the strongest forms of evidence in a probation revocation hearing. The surprising part? The discussion now shifts from punishment to whether he's still worth another opportunity.
True.
True.
Count 8 in each case alleges that you were behind in your court-assessed fees. And is that true or not true?
True.
Did you enter your pleas of true in each case to counts 2 through 8 freely and voluntarily? And did you plead true to those counts because they're actually true? So it's my understanding, Mr. Chapman, that the recommendation is that I continue your probation and order you to enter and successfully complete the special needs safety. Is that your understanding?
Yes.
Is there any reason to get any type of pre-sentence report or update?
Only at the court's discretion, Judge. The officer, Ms. Valier, has already prepared for the court the continuation and modification of that special condition if the court would like that to be signed off on today. Otherwise, I'm sure she'd be happy to do a quick update.
If it's her recommendation, we'll just go ahead and go forward. So
I think that was, I'm sorry to interrupt, I think that was done prior to.
This is one of those moments judges rarely waste words on. Listen carefully to the tone. She's not just talking about legal consequences. She's talking about personal choices. The court is acknowledging that the murder allegation didn't stick, but at the same time pointing out a harsh reality. Being in the wrong place at the wrong time while already on probation can put your entire future at risk. Have you ever seen someone get lucky enough to avoid disaster, only to keep making the same mistakes afterward?
To count one that we see, which obviously caught everyone's attention and took that immediately off the table. But
Right.
once that was no build, I think that's when she finds herself back in that position.
So, Mr. Chapman, you're getting your second chance today.
Yes, ma'am.
There's not going to be a third. Okay. You need to take advantage of this. I don't know what happened. The night of December 21st to 25, obviously it was no build as far as the offense, but you were clearly somewhere you shouldn't have been doing some things you shouldn't have been doing, right? If you had been home during curfew, you never would have been charged with anything. There wouldn't have been any issue of whether or not you did anything, right?
Yes, ma'am.
So I want to make sure you understand if I go along with this and send you to safety, you're going to get some tools so that you can hopefully stop using drugs, do the right thing, live your life like the rest of us, and not end up in prison. Do you understand all that?
Yes, ma'am.
All right. So at this time in each of your cases,
I don't know how the court would feel about an extension, Judge, based on the age.
yeah. So at least in the evading, I'm going to do that. I'm also we're going to talk a little about the jail incident reports as well in just a minute. So I'm going to find in each of your cases that you entered your pleas of true to counts 2 through 8 freely and voluntarily. Find those counts true. Find sufficient evidence in each of your cases to revoke your probation. But I'm going to go along with this agreement today, and I'm going to continue your probation in each of your cases. In cause number 23 DCCR 1077, I am going to extend your probation by 2 years. And I'm going to order in each of your cases that you enter and successfully complete safety. That obviously means going through the program in custody, but it means getting through the.
And here's the bombshell. Dakota is walking away today without felony convictions on his record, despite admitting multiple violations. That's an incredible amount of leniency. But notice the trade-off. The judge isn't removing the consequences. She's postponing them. If he fails again, those deferred cases could become real felony convictions. And prison time is suddenly very real. This is a legal equivalent of standing on the edge of a cliff and being told, don't take another step.
Aftercare and everything else successfully. If you do all of that, then you're still on these deferred probations. You still don't have felony convictions on your record. This is, again, the opportunity of your lifetime right now for you to make the changes and do the right thing. If you don't, and you come back in here, then you are going to end up with 2 felony convictions, and you're going to end up going to TDC for up to 10 years in one case and state jail prison for up to 2 in that case. Do you understand?
Yes, ma'am.
Let me explain something else. I am also now making it a condition of your probation that you treat the staff and the correctional officers at our jail and at safety and wherever you are with respect, and you follow all of the rules when you're incarcerated. That means if I get another incident report before you get to before you get to safety, it's already a violation of your probation. They're going to let me know, and you're never even going to make it to safety. You're going to be right back in here and looking at going to prison. Do you understand?
What makes this section fascinating is that the judge isn't focused solely on drugs or probation violations anymore. She's focusing on behavior and attitude. Why? Because correctional staff reports often give judges insight into how a defendant responds to authority when nobody's watching. According to these reports, Dakota wasn't just breaking rules. He was allegedly showing open disrespect toward jail staff. And in many courts, that kind of conduct can completely change how much patience a judge is willing to have moving forward.
Yes, ma'am.
So the way you're talking to them at our jail, you cannot keep doing that. You cannot keep arguing. You can't keep fighting. You can't keep saying, F that, I don't care, things like that. Okay. And you're looking at me like you're confused that maybe you didn't do these things, but this is what I have. Every time you act up, every time you tell someone, if you're going to send me out, just do it, F that, or whatever it is, that's disrespectful.
Yes, ma'am.
All right. They're just trying to go there and do their job every day. Hopefully someday that's what you want to do. Get out of jail, go to work, and not have somebody treating you like this when you're at your job. Right?
Yes, ma'am.
All right. So you'll sign some paperwork today for safety. And
In the end, Dakota Chapman leaves his courtroom with something many defendants never receive: another chance after openly admitting multiple probation violations. But make no mistake, this wasn't victory lap. It was a final warning wrapped in mercy. The judge gave him treatment, time, and an opportunity to avoid felony convictions. But she also drew a line in the sand. Now the story moves beyond the courtroom. The next chapter won't be decided by lawyers or judges. It'll be decided by Dakota himself. What do you think? Did the court make the right call by giving him another chance? Or should probation have been revoked immediately?
I think that's it as far as adding the condition. So add 2 years in the one case and the condition with regard to being successful and not being disrespectful.
Yes,
Okay?
ma'am.
All right. Good luck to you. You can go back with the bailiff.
In the end, Dakota Chapman walked out of this hearing with something most defendants never get: another chance. But the judge made one thing crystal clear: this wasn't freedom earned. It was freedom borrowed. Now the real question is, will this warning change his life?